In a significant development in the litigation surrounding India's worst industrial disaster, the Bhopal gas tragedy, a constitution bench of the Supreme Court dismissed the curative petition filed by the central government seeking to reopen the settlement reached in 1989 with the Union Carbide Corporation, now known as the Dow Chemicals. This petition was filed claiming additional compensation for victims of the Bhopal gas tragedy. So before we discuss as to what happened in the Supreme Court today, let's first talk about what events led to the union filing this curative petition before the Supreme Court. So you all must have heard about this tragedy that took place in the Bhopal gas plant. This case has a long legal history in terms of prosecution. In close to 20 years of litigation, the case has seen a lot of twists and turns. In the year 1984, the gas leak at the Union Carbide plant in Bhopal killed nearly 4,000 people, leaving generations thereafter reeling under the harmful effects of methyl isocyanate gas. Today's development came years after the Indian government filed the curative plea in 2010, seeking additional compensation from Union Carbide Corporation, that is the UCC, which ran the Bhopal gas plant. If we look at the entire picture from the legal perspective, what happened was, after the tragedy took place, Union government filed a case in the Federal District at New York, claiming about $3 billion in damages. However, it was dismissed on the reasons of jurisdiction, directing to follow the jurisdiction of the Indian courts. And hence, a suit was filed in the district court in Bhopal, where Union Carbide was directed to pay Rs 350 crores to the victims of the gas leak. After this, when an appeal was filed before the Madhya Pradesh High Court, the High Court reduced the amount of compensation from 350 crores to 250 crores. Now, this decision was then challenged by both the parties, the corporation and the union government, before the apex court. The Supreme Court asked the parties to explore the possibilities of settlement, and as a result, in 1989, the settlement of $470 million was reached between both the parties. This was affirmed by the Supreme Court itself. At this time, the Union Carbide was being represented by senior advocate Fali Nariman. Subsequent to this settlement, several review petitions were filed by various organizations and the union government itself. However, the Supreme Court refused to increase the amount of settlement. Then again in 1991, the union government's petition to reopen the settlement was dismissed. And finally in 2010, the Government of India had filed a curative petition praying for Rs 7,844 crores in excess of the settlement amount already disbursed by the Union Carbide, contending that the settlement was based on incorrect assumptions about the quantum of deaths, injuries and losses. The apex court today has given a finality to the matter. The Constitution bench, comprising Justice S.K. Kaul, Justice Sanjeev Khanna, Justice A.S. Oka, Justice Vikram Nath and Justice J.K. Maheshwari also observed that the previous settlement can be set aside only on the ground of fraud, and no such ground of fraud has been pleaded by the Union of India. The bench was baffled that it took the Union government 25 years to realize that the compensation fixed in 1989 was inadequate. It further noted that the Union government had itself failed to take out insurance policies as directed by the Supreme Court before. The court stated, and I quote, "The responsibility was placed on the Union of India, being a welfare state, to make good the deficiency in the compensation and to take out the relevant insurance policy. Surprisingly, we are informed that no such insurance policy was given out. This is gross negligence on the part of the union and in breach of the judgment of this court. The union cannot be negligent on this aspect and then seek a prayer from this court to fix such responsibility on the Union Carbide Corporation. The court was also unsatisfied with the Union of India for not providing any rationale for raking up this issue more than 2 decades after the incident. It was noted that the union's case is based on the number of victims and injuries which were not foreseeable at that time when the settlement was reached. However, interestingly, during the 2004 proceedings, it was duly admitted that the amounts were sufficient to meet the actual requirements. And even if there are more claims, than envisaged at that time, then the excess amounts of funds which are available must be used to satisfy those claims. In view of this, the court directed that a sum of rupees 50 crores 25 lakh lying with the Reserve Bank of India ought to be utilized by the Union government to satisfy the pending claims. That was all for today's video. Do not forget to like and subscribe to our channel, and for more such videos, keep watching LiveLaw.